Once escrow has been opened and the earnest money deposited, the next phase begins. Escrow instructions. These instructions guide the entire process from start to finish, serving as the escrow officer's roadmap for closing the transaction. While the real estate purchase contract outlines the agreement between the parties, escrow instructions detail the steps required to fulfill that agreement, from collecting documents to dispersing funds and recording the deed. What are escrow instructions? Escrow instructions are written directions provided to the escrow officer by the buyer and seller. They authorize the officer to take specific actions necessary to close the transaction, such as paying off liens, ordering title insurance, and transferring ownership. In Arizona, these instructions must be in writing, signed by the parties, and are legally binding. This requirement comes from ARS, paragraph 6834, which mandates that all escrow disbursements and document transfers occur only in accordance with written instructions. Example: a buyer in Mesa signs escrow instructions authorizing the escrow officer to pay the seller's existing mortgage from sale proceeds, deduct title fees, and record the warranty deed once all lender conditions are met. Escrow follows these instructions exactly, no more, no less. Escrow officers cannot act on verbal directions or assumptions. This maintains neutrality and compliance with Arizona escrow law. How escrow instructions relate to the purchase contract. While the AAR residential resale real estate purchase contract provides the foundation for the transaction, escrow instructions are the operational blueprint. In fact, many title and escrow companies in Arizona reference the AAR contract directly within their instructions, stating that the contract is incorporated by reference. However, if there is ever a conflict between the escrow instructions and the purchase contract, Arizona law gives priority to the written escrow instructions, since they represent the most recent, specific, and signed directions to the escrow holder. Under Commissioner's Rule R4-28-1101A, agents must protect their clients' interests by ensuring the escrow instructions accurately reflect the agreed-upon terms in the purchase contract and any amendments. Example: a Chandler buyer negotiated a $5,000 seller credit for closing costs in an addendum. However, when the escrow instructions were prepared, the credit was mistakenly omitted. The agent caught the error and notified escrow immediately. Because of this attention to detail, escrow amended the instructions and avoided a major closing day dispute. Amending escrow instructions. As transactions evolve, so do their terms. Repairs, price adjustments, and closing extensions are common in Arizona real estate, and each change must be reflected in amended escrow instructions. Amendments must be signed by all relevant parties and become part of the permanent escrow file. Escrow officers cannot act on emails or verbal authorizations alone. This requirement protects all parties under ARS paragraph 6834B, ensuring the escrow company remains neutral and compliant. Common reasons for escrow amendments include change in closing date or possession date, price change due to appraisal results, repair or credit agreements, changes to how title will vest, ownership names or marital status, adding or removing buyers or sellers. Example: a Queen Creek buyer's lender requested an additional 3 days to finalize underwriting. The parties signed an escrow amendment extending the close of escrow date from May 15th to May 18th. Escrow updated the instructions, avoiding potential breach of contract claims. Failing to document changes can lead to serious liability for both agents and clients, especially when disbursement amounts or recording dates are affected. Escrow closing documents. In addition to the escrow instructions, several key documents are signed by the buyer and seller during the final phase of escrow. These may include 1. Deed transfers legal ownership from the seller to the buyer, usually a warranty deed under ARS, paragraph 33401. 2. Settlement statement, ALTA closing disclosure. Itemizes all costs, credits, and disbursements. 3. Loan documents, promissory note, deed of trust, and lender disclosures if financing is involved. 4. Affidavit of value, ARS Parapho 11, 1133, required for all recorded transfers to report sales price and establish property tax value. 5. Warranty and condition disclosures, seller provided statements verifying property condition and any known defects. 6. IRS Form 1099-S, reports the sale to the IRS for tax purposes. Escrow officers ensure all documents are signed, notarized, and recorded in the correct order. Once the deed records, escrow releases funds according to the instructions. This moment marks the close of escrow, COE. Recording and disbursement. The escrow officer cannot disburse funds until the county recorder confirms the deed has been recorded. This step, required under ARS Paragraph 33-4111, ensures that ownership officially transfers before the seller receives payment. Example: in a Scottsdale closing, the buyer's loan funded at 11 a.m. and the deed recorded at 2:45 p.m. Only after confirmation from the Maricopa County Recorder did escrow release funds to the seller and notify both agents that escrow was closed. This sequence protects all parties and ensures that ownership, possession, and payment occur in the correct legal order. Agent's responsibility under R428-1101E, agents must ensure that all material terms of the contract are reflected in the escrow instructions. This includes reviewing drafts for accuracy, confirming that any addenda are incorporated, and verifying closing credits or repairs appear correctly on the settlement statement. Agents should also ensure clients understand what they are signing. Escrow officers are not allowed to interpret or advise on the legal meaning of documents. They can only explain general procedures. If a client is uncertain, the agent should recommend consulting an attorney, fulfilling their obligation under R4-28-1101K to suggest professional assistance when beyond the agent's expertise. Arizona example. In a Tempe investment sale, a buyer purchased a duplex using a 1031 exchange. Escrow instructions had to include additional provisions directing funds through the qualified intermediary, QI. Because the agent was familiar with 1031 exchange procedures and ensured the QI instructions were included, the transaction closed smoothly and met IRS timelines. Without the amendment, the buyer could have disqualified their exchange and owed substantial capital gains taxes. Key takeaways. Escrow instructions are the written blueprint that ensures the transaction closes legally and correctly under ARS paragraph 6.834. They must align with the purchase contract but take precedence when discrepancies occur. Agents play a crucial role in reviewing and amending these documents, ensuring all changes are in writing and accurately reflect the party's intent. Proper communication, documentation, and attention to detail prevent closing day errors and uphold the agent's duties under R428-1101.